Corruption of Foreign Public Officials Act is a Canadian piece of legislation that came into force in 1998. It deals with the issue of bribery of foreign public officials by Canadians and Canadian businesses. There are basically 5 elements to this offense. The first element is that it must be committed by a person. A person includes not only a real person, but also a corporation and other business associations. Secondly, the person must directly or indirectly give or agree to give some sort of advantage. Thirdly, the bribe must be for the purpose of obtaining or retaining an advantage in the course of business. Fourthly, the bribe must be for the benefit of a foreign public official. Fifthly, the bribe must be to induce the official to do or not do something in his capacity as a foreign public official, or it must induce him to exert influence over his government. The penalties under the Corruption of Foreign Public Officials Act currently are a maximum of 5 years in jail. However, this will soon be revised to a maximum of 14 years in jail. And there's also the ability of the courts to levy a fine. There is no limit as to the amount of the fine. The offense of bribery is also an indictable offense. There are defenses to the charge of bribery. The first one is that the payment is permitted, meaning that it is permitted by the law of the country of the foreign public official. The second defense is that the payment was a reasonable expense incurred by or on behalf of the foreign public official. The third defense is that in fact the alleged payment was a facilitation payment. Alleged offenses under the Corruption of Foreign Public Officials Act are investigated by the Commercial Crime Branch of the RCMP. Currently there are 2 locations. One is based in Ottawa and one is based in Calgary.